Hello everyone. In the last presentation, we have seen that Winfield's definition is considered to be the best by many jurists. According to Winfield, tortious liability arises from a breach of duty imposed by law and which is owed to the public at large, which is redressed through an action for unliquidated damages in a civil suit. Thus, the basic elements of tort are a wrongful act, legal damage, and legal remedy. Wrongful act includes violation of a legal right, that is, a right conferred by law or a breach of duty imposed by law. When the legal right of the plaintiff is violated, there is a breach of duty on the part of the defendant, which amounts to a tort. When A owns property, the law confers on him a right to peaceful enjoyment of the property and imposes on everyone else a duty to respect the right of A and not to unlawfully interfere with it. Thus, if B enters upon the property without A's permission, he had breached the duty imposed upon him not to interfere with A's property, which results in the violation of A's right, resulting in a tort of trespass. Here, A can sue B for trespass in a civil court and claim compensation for the wrong suffered. Where the duty imposed is a public duty and the right available is a public right, where A violates B's public right, A will be liable to compensate B only when B proves that he had suffered special damage or loss in addition to that suffered by the general public. Where A piles up debris on a public road, blocking the right of way, which is a public right, and B, whose house opens on the public road, is blocked by the debris thrown, thereby making it difficult for him to enter or leave the property, the damage suffered by B is special and is in addition to the damage suffered by the public at large. Only in such cases, the plaintiff can sue the defendant for compensation for breach of a public duty or for violation of a public right. Now, legal damage. The next element is legal damage. What is legal damage? In order to bring an action for tort, the harm, loss, or damage caused to the plaintiff must be because of the violation of a legal right, that is, a right vested by law, or due to breach of duty which is imposed by law. When the harm caused or loss suffered is not due to infringement of a right of the plaintiff or breach of duty imposed by law on the defendant, the damage is not legal damage and hence cannot be redressed. Damage must be the direct consequence of the defendant's act. It may be harm caused to the body, mind, reputation, or property of an individual. There are two maxims which lay down this principle. Injuria sine damnum is actionable as a tort, but damnum sine injuria is not actionable as a tort. Now, what does that mean? It means that where there is injuria without damnum, that is damage, that is injury without damage, there is a tort. Injuria, as has already been explained, is infringement of a legal right or breach of a legal duty. Hence, where there is a violation of a right or a breach of duty by the defendant, even if no damage or loss is suffered by the plaintiff, he can sue the defendant in the tort. For example, A, who has a right to vote, is obstructed and denied his right, but the candidate to whom he intended to cast his vote wins, and hence A suffers no loss for such violation. He can still claim compensation for being denied his right to vote. The second maxim is damnum sine injuria, which is not actionable as a tort. This means that though A suffers damage or loss due to B's act, but the act is neither an infringement of a right or a breach of duty, A cannot sue B in tort. Where A digs a well in his land up to 60 feet and has abundant groundwater, but B, his neighbor, digs a well in his land up to 120 feet, thereby reducing A's source of groundwater, B cannot be held liable for the damage suffered by A because A does not have any exclusive right over groundwater and hence no right of his is infringed by B. Hence, injury, that is infringement of a legal right, is the basis of an action in tort and not damage or loss suffered. Then legal remedy. There has to be a remedy which is legal, that is provided by law for violation of a legal right. This is governed by a maxim ubi jus ibi remedium, which means that where there is a right, there is a remedy. When law vests rights or imposes duties and there is a violation of the right or there is a breach of duty, the law has to provide some remedy for such violation. In torts, the remedy is in the form of unliquidated damages. Damages here is the compensation that has to be paid by the defendant for the injury suffered by the plaintiff. This compensation that has to be awarded cannot be pre-assessed or pre-estimated by the parties, but will be decided by the court based on loss suffered by the plaintiff, which again depends on the facts and circumstances of the case. Action for unliquidated damages is an essential characteristic of tort. Here, the damages are awarded for violation of a right and hence, even where no loss or harm is suffered by the plaintiff, a nominal amount as a recognition of his right can be awarded by the court. Specific restitution of property, that is, the return of the property instead of compensation, may be ordered when the court feels that compensation is not an adequate relief. Injunction directing a party to do something or not to do something or to maintain status quo may also be ordered when compensation is not an adequate remedy. Thus, a wrongful act, that is violation of a legal right or legal duty, resulting in legal damage, and legal remedy, that is remedy recognized by law, are the three essential elements of tort. Now, how is a tort different from a crime? Both tort and crime are violations of rights in rem, and in both cases, duty is imposed by law and not by private parties like in contract and trust. But tort is a private wrong while crime is a public wrong. That is, tort is a breach of private duty while crime is a breach of public duty. In tort, the object of bringing an action is reparation or compensation, whereas in crime, the object of bringing an action is to punish the wrongdoer. In tort, the individual suffering the wrong has to initiate action against the wrongdoer, whereas in crime, the state initiates prosecution against the wrongdoer and maintains a machinery for investigation and trial of crimes following specific procedures laid down by law. Now, how is a tort different from a breach of contract? In tort, the duty is imposed by law, whereas duty is imposed by the parties in a contract. Now, what is a contract? It is an agreement between two or more parties, and here, when the agreement satisfies all the conditions that are laid down by law, and there is a breach of this agreement, then the party who suffers the breach can approach the court for liquidated damages or for a relief that is provided by law. So far as a contract is concerned, the duty is imposed by the parties to the contract. Tort is a violation of right in rem, that is a right available against the world at large, whereas a breach of contract is a violation of a right in personam, that is the right available against particular individuals who are party to the contract. Intention sometimes is relevant in tort, like in the tort of malicious prosecution, nuisance, etc. There is a requirement of proving intention with which the act is done, whereas intention is irrelevant so far as contractual liability is concerned. In tort, damages are unliquidated, whereas in contracts, damages are liquidated. That is, they can be pre-estimated. That is, even before an action can be brought for any violation, or even when at the time of entering into an agreement itself, the parties can assess the quantum of loss that the party would suffer if one of the parties breached the contract. Thank you.